So 22 states have joined together to demand that the Supreme Court finally take up a case which will put an end to the ATF's Second Amendment violations. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more, you can use the link down in the details section, and thank you again SDI for sponsoring this video. So like I said in the intro, 22 states have joined together to file an amicus brief to the Supreme Court. The 22 states effectively argue in their brief that it's finally time for the Supreme Court to strike down the ATF's continued Second Amendment violations. This brief by the 22 states was filed in the GOA v. Garland case, which challenges the ATF's interpretation of bump stocks as actual machine guns. The 22 states who joined together in this brief are Montana, West Virginia, Alabama, Alaska, Arizona, Arkansas, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah, and Wyoming. Now, although this case deals directly with bump stocks, the larger implication of this case is really a challenge to the ATF's arbitrary interpretation and rulemaking process, which results in the agency being able to ban whatever firearms and devices that they choose. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the Las Vegas incident, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to actually be machine guns. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them to the ATF. This change in definition made possessors of bump stocks subject to punishment of 10 years in prison and or a fine of $250,000 if they failed to destroy or to surrender the devices. Effectively, the ATF made possession of a device a felony overnight simply because they said it was now illegal. Now, the case here is a challenge to the ATF's final rule on bump stocks, which was led by GOA. This case was determined in favor of the ATF at the district court level and eventually made its way up to the Sixth Circuit en banc panel. After hearing oral arguments, the Sixth Circuit issued their order, and it was a rare deadlocked 8-8 decision. So essentially, since the Sixth Circuit en banc panel was deadlocked, the tie went in favor of the ATF, who had won at the lower court level. This split between the judges on the Sixth Circuit came down to the pro-ATF side, saying that Chevron deference supports their interpretation of bump stocks as machine guns, since the term, in their opinion, was ambiguous. In contrast, the other side of judges says the term is not ambiguous, and bump stocks were never intended to be included in the term machine gun as defined. This side also argued that courts have improperly used the doctrine of Chevron instead of using the rule of lenity when criminal punishments were at stake. If you're not aware of what Chevron deference refers to, Chevron deference is a term coined after the landmark case, referring to the administrative law principle that compels federal courts to defer to a federal agency's interpretation of an ambiguous or unclear statute that Congress has delegated to that specific agency. So when a statute has ambiguous terms, the agency responsible for enforcing that statute may be able to determine what the term was intended to mean as long as their interpretation is rational or reasonable. In contrast to Chevron deference, the rule of lenity indicates that when dealing with a statute that has criminal implications, a court is required to apply any unclear or ambiguous term in a way that is most favorable to the people, not the enforcement agency. At stake in this case is the ATF's interpretation of the definition machine gun. One side says that under Chevron, courts should defer to the ATF's interpretation that bump stocks are machine guns. The other side says, first, that Chevron doesn't even apply because the term machine gun is very clear in the statute and the definition clearly indicates that bump stocks are not machine guns. This side also says that even if the court were to find the term machine gun ambiguous, the rule of lenity would direct a finding in favor of the people, not the ATF, since there are serious criminal implications at stake with that interpretation. Now, in response to the Sixth Circuit's deadlocked opinion, and after that ruling, GOA decided to file for Supreme Court review, and that is currently where this case is at. This case is still making its way through the process, but 22 states have now joined into this case, arguing that the Supreme Court finally needs to address this issue. In their brief, the 22 states make three main arguments. First, that the court should clarify the interplay between Chevron and the rule of lenity. Second, that the application of Chevron to a criminal statute implicates serious separation of power concerns. And third, that an agency's interpretation should not receive deference when it diminishes a fundamental right. In the first argument section, the 22 states argue that, like Chevron, the rule of lenity presumes that two reasonable interpretations of a statute exist. But the similarity stops there. The rule of lenity gives the benefit of the doubt to the criminal defendant instead of the government. But Chevron is the mirror opposite. It gives the benefit of the doubt to the agency, even if an individual might reach a reasonable but different interpretation of the rule. The doctrines are thus operating at cross purposes. Giving persuasive effect to the government's interpretation of criminal statutes would turn the normal construction of criminal statutes upside down, replacing the doctrine of lenity with a doctrine of severity. Therefore, the states argue that the rule of lenity should always be considered at a step before Chevron deference. And after the rule of lenity is considered, if the court finds that it doesn't apply, then they can move on to look at Chevron. In the second argument section, the 22 states argue that using Chevron when criminal charges are implicated creates a serious separation of power issue. In this section of the argument, the states hit on a big issue that we as gun owners have been pointing out for a very long time. That is, if courts use Chevron to simply defer to the ATF's interpretations, then the ATF goes simply unchecked. If courts give deference to the ATF's interpretation automatically, not only are the courts saying that the ATF gets to decide what the law is, but also they then get to enforce their own interpretation, which carries with it very serious criminal charges, often felonies. Effectively, that makes the ATF the judge, jury, and executioner, which obviously isn't right. However, that is how the ATF has been operating, and that's why you see the agency aggressively going after various items like 80%ers, bump stocks, pistol braces, triggers, and solvent traps. All of those attacks are a direct result of the ATF's unchecked interpretations, and the rule of lenity is really what needs to be used to prevent that from happening anymore. Finally, the states argue in their last section that the ATF's interpretation should not receive deference since it diminishes a fundamental right to keep and bear arms. They argue that the Supreme Court has long recognized in the constitutional doubt canon that courts should construe statutes to avoid interpretations, even reasonable ones, that raise serious constitutional concerns. The state's position is that interpretations like the ATF's should be per se unreasonable when they impair fundamental rights, especially in the criminal law context. The argument here is a basic one, but it's very profound. Courts should not defer to an agency's interpretation when that interpretation would directly weaken, impair, or lessen a fundamental right. If an agency's interpretation weakens a right, well, then the interpretation should automatically be dismissed and found unreasonable. So that's a quick rundown of the brief filed by the 22 states in the ATF bump stock ban case. The main thrust of these states is that the ATF has been allowed to decide willy-nilly what the law is and then enforce it against Americans. These states argue it is finally time for the Supreme Court to use its powers and pretty much put a check, like our checks and balances, our natural checks and balances, on ATF overreach and these types of actions. So we will see if the Supreme Court is persuaded by the 22 states in their brief, but regardless, it's nice seeing states join together to fight against the ATF and their overreach. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought or could ever do on my own. So thank you so much for all of your support. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget to stay built by armed scholars and stay we maintain armed scholars.